Good afternoon, everyone. It's a joy to be here today with Allison Matthews, one of our GML 207A and C experts. I'm in Syracuse. Allison is in Garden City. And just by way of brief introduction, I'm a labor and employment law attorney in the Syracuse office. I practice general labor in the private and the public sector, handling things like arbitrations, contract negotiations, disciplinary matters, as well as general employment discrimination cases. So just wanted to give you that introduction. You can see my contact information here. And Allison, can you just provide the group with a brief introduction of your background, please?
So I am also a labor and employment attorney, and I work in private and public sector as well. In addition to all the things that Colin listed, I do collective bargaining. I work with unions and do their negotiations, handle grievances, unfair labor practices, improper practices, and I've done some negotiations over 207A and C procedures, as well as some hearings over those. So I think we're going to get to some of those topics today.
Great, thank you. If you could advance the slide, please, Kathy. All right, so here's just what we're going to try to cover today. I would just say this at the outset. This is a very complex area, statutory provision, and it's made even more complex, not the least of which because of the statutory text and the case law that's emanated from the statute, but also the interplay that it has with other civil service law provisions, collective bargaining agreement that you may have in place, as well as what your practices might be in your particular municipality. So it's an area that is robust with potential pitfalls, and in my experience, it's very good to, from the very beginning, consult with legal counsel or HR personnel department in your organization to make sure you're working through this correctly. So what we're going to do today is just give a brief introduction. We're going to go through some of the basics on how the law works, the benefits in terms of what the two statutory provisions provide. We're going to talk a little bit about the return to work options. And obviously, this is a disability benefit provision. So the idea here is we're always trying to work toward the return to some kind of duty for the individual police officer or firefighter. And sometimes that's just not going to be the case. So we'll talk through, that as well. We're going to talk a little bit about the retirement options that are available under the statutory provisions, as well as what can happen in terms of a termination of employment while someone is on 207A or C. I think Allison's going to talk a little bit about the bargaining obligations that arise in the course of this process, because obviously these are areas that unions and employers want to cover very carefully in their collective bargaining agreements, because of the significant cost that these statutory provisions can impose on an employer. We're going to talk about a few best practices and obviously try to cover any Q&As that arise over the course. If you have some as we're talking, you can throw them in the chat and we'll try to address them as we're going on, or you can wait till the end and we'll address them then. So if you could just advance. Thanks, Kathy. So just in terms of what we're talking about, as I said, this is a disability benefits provision like workers' compensation, generally applicable in New York, but it's much more significant, and it provides, as I said, the paid firefighters are going to be covered by what's called 207A, and police officers and certain other stated law enforcement personnel are covered under the 207C provisions. But essentially, it's an enhanced workers' compensation system, and it's really intended to address the more significant risks that firefighters and police officers are subject to as a result of their employment. This has a very long background. in New York State, as long ago as the late 19th century, we saw what was happening in the eastern United States is cities on the East Coast were moving from primarily volunteer fire departments to a much more paid operation. And certain cities began to offer these significant pension benefits for paid firefighters specifically. But it wasn't uniform. And so some cities would have these enhanced benefits and others would not have it. So there was some disparity among the cities. So what New York did is in 1938, the precursor to 207A was enacted. And we've been dealing with, I guess, almost 90 years of statutory changes and case law treatment in the area to try to better understand these areas. If you could advance, please. So as I said, this is an enhanced benefit, provides a benefit because of the increased risk to firefighters and police officers as the course of their employment. And basically it has two components, which when I say it sounds very simple, although it's really hard to unpack all of this. But an employee is entitled to receive, and an employer is required to pay the employee's full salary, and we'll unpack what that means in a little bit as we get into this, and then the costs of medical treatment and hospital care necessitated by the employee's injury or illness. So, you contrast this with what workers' compensation generally provides in New York, which is about 2/3 of the employee's pay, subject to a set off in terms of what the extent of the disability is, 100%, 75, 50%. But it's never going to be the employee's full salary. So it's a much more robust and significant benefit for the firefighters and police officers. Next slide, please. One of the key aspects and one of the most litigated areas is the employer's right to make the initial determination. So that's the fire chief or police chief or commissioner or other committee that you have under your municipal charter or provisions of local law to make the initial determination. And that is a significant right that employers maintain. That's a statutory right, meaning that it actually cannot be bargained away. It's a prohibited subject under the Taylor law to bargain away the right to make the initial determination. So unions have tried, for example, there's a case involving the city of Poughkeepsie back in 2005, where the unions tried to create a situation proposed in bargaining that an arbitrator would have the right to create or to make the de novo review or a kind of a fresh start review, brand new review following the chief's initial determination. And that was litigated, and the court found, PERB found, and the court found that that's a prohibited subject of bargaining. The city retains that right. Unions got a little bit more creative and tried to create a review process, which didn't use the words de novo, but also amounted to essentially kind of an appeal process of whatever it was that the chief was making a determination on. And so that again was litigated and was found to be a prohibited subject of bargaining. So whatever you do, and we'll talk about bargaining as we get through this process, whatever you do, it's really fundamental to the city's right to be able to make that initial determination as to whether or not the person is entitled to benefits under the law. Then once you've made that initial determination, there are other things that the employer has the right to do, as set forth here in the slide. Things like get an IME scheduled, prescribe certain types of treatment, and return the employee to work, either full or light duty. And we'll talk through some of those things. But for example, if there is a surgical need that the doctor for the municipality believes is necessary, you as the employer can require that surgery to actually occur. So it's important as we work through these issues to try to understand what rights you retain, even if they're not exercised as an employer. The rights that you retain can be used as leverage as you work through either negotiations or a particular case, and that can present some difficult issues. So let me turn it over to Allison to talk about some of the other basics.
Thanks, Colin. So Kathy, we're going to go forward 2 slides. And so as Colin mentioned, these are 2 statutes that are designed to provide enhanced workers' comp type benefits to firefighters and police officers. Because it's designed to help those individuals who are injured in professions where the likelihood of being injured is greater, it's been found by the courts to be a remedial statute. And what that means is if we get into an argument about which way we're going to sway towards the employer or towards the employee, the court is going to sway more towards the employee and construing that statute in favor of helping those employees who are injured in the line of duty. Just because an employee is hurt at work doesn't mean they automatically are going to be found eligible for 207, just like they're not automatically going to be found eligible for workers' comp. The standard here is the direct causal relationship between the job duties and the injury. And this is something that's one of the critical decisions that you have to make when you're making that initial termination, is to figure out, was the employee performing job duties at the time, and did the performance of that job duty actually result in an injury? Prior to the Court of Appeals decision in Thoreau versus Riley, there was a whole body of case law that said that because we're talking about an enhanced workers' comp benefit, that it's an enhanced standard, meaning that you have to be performing a job duty that has a heightened risk of injury. Thoreau did away with all of that, and now we're talking about the full range of an employee's duties. So if you're looking at cases and you're trying to figure out what the standard is, make sure you're looking post 2003, and we're just looking for that direct causal relationship, and it can be any job duty that an employee is performing. So we'll go forward 1 slide, Kathy. All right, so there's a difference between being eligible for workers' comp and being eligible for genuine municipal law 207 A or C benefits. Oftentimes, if an employee is receiving A or C benefits, they're also receiving workers' comp, but one doesn't necessarily lead to the other. And it's a fact-based inquiry in terms of whether the job duty that the employee was performing falls under workers' comp, A or C, or both. And it's kind of a I know it when I see it type thing when that comes up. So this case out of the county of Albany gives a good example where we have a correction officer who's at a visitor's booth and he hurts himself when he's removing the garbage from the booth. And the court said that that officer is not, his job duty is not taking out the garbage. That's something that's normally been performed by a maintenance worker. So even though while this correction officer was in the post in this booth and had the obligation to keep that space clean, it really wasn't one of his job duties. So that there's no direct causal relationship there, because even though he was injured and he was injured at work, it's not related to the officer's actual job duties. Sometimes employees do have pre-existing conditions and they can be exacerbated in the course of performing their duties. Just because that condition was in existence before the employee got injured on the job doesn't mean they're barred from ever getting 207A or C benefits. We're still looking for that direct causal relationship. But again, it's more than just timing. The fact that someone was working at the time and they happen to be injured doesn't necessarily mean that we're going to end up with a causal relationship. And there is a whole body of case law on this as well. And a lot of times it's 2 things that will come into play, and we'll probably get into this a little bit later. Not only is it the employer who's looking at what was going on and investigating what was going on at the time of the injury, but sometimes you need a medical opinion too, to figure out if what the employee was doing actually could have caused the injury that they're alleging the connection to. Once we get to the point of an employee being found eligible for the benefits, it's a vested constitutional property right, which means we can't just go in, because we're talking about municipalities, we're the government, we can't just take it away for the employee without some sort of due process. In the general sense, due process is notice and an opportunity to be heard. That's the basic bottom level amount of due process. But most municipalities will have a procedure in their contract about how it is that you can move someone on and off of 207A or C, and that sets the boundaries of what their due process is. So if you think that you can only do notice and opportunity to be heard, that's not the case. You're going to have to go through whatever procedure is in the contract. Because this is a vested benefit, there are only certain circumstances that cause employees to quote unquote lose the benefits. So if they're no longer disabled, they're not hurt anymore, they're not sick anymore from whatever was causing that injury or that illness. If they've reached the mandatory age for retirement, that ends the benefits. If they voluntarily retire, and it doesn't really matter as long as they retire, it could be disability, it could be accidental, it could be service related. Either any of those are going to be something that is going to make sure that the employee is going to be no longer qualified for the benefits. With the disability, it's really the police only. The firefighters have a couple of enhancements in their statutes where it's better than what the police receive. And we are going to talk about that a little bit later, but even after the employee retires, those benefits will continue. So I think that brings us to what the benefits actually are, which Colin's going to cover.
Yeah, thanks, Allison. And just before we leave that piece too, I think it's just on a practical standpoint, in my experience, and I don't know if Allison has the same experience, but very often you'll be discussing this area with a union attorney or a union representative for the police or the firefighters, and they will use shorthand for the concept that it was an on-the-job injury. They use on the job, and it's very distinct from the performance of duties. As Allison outlined, we no longer have the pre-thorough enhanced benefit or enhanced risk standard, but we still have the critical language in the statute, which is performance of duties, not just on the job. So I think just keeping that in mind as you're working through some of these issues, they're all, fact-based, obviously. And so we need to be careful when making that initial determination, because once you've made that, it's really hard to drag back without some real slogging through things. Okay, the benefits. So as we talked about, the benefits that are afforded under 207 are either A or C, are the statutory benefits. They're set forth as the standard, meaning they can't be eviscerated, but you can, through collective bargaining, enhance those benefits even further. So they set essentially the floor, and as parties negotiate through the back and forth of negotiation, an employer may agree in a certain circumstance to enhance the benefit as a trade-off for some other give back, but they are the floor, and you can go up from there. I would say this about procedures. I agree with Allison. A lot of the municipalities that I work with have negotiated a procedure, but I do get asked sometimes, certain departments may not have one. And the question is whether or not they want to go through the process of outlining it. And as we'll talk a little bit later on about the negotiability of that process. But there are some benefits to not having a process if you're the employer, as long as you're acting fairly and consistently, which I know can be tricky because maybe you have people changing hats over the course of years. But they're just because you don't have a 207 procedure, I don't think is the end of the world. I think you can benefit from that process because it does give you a little bit more discretion than the procedure. Now, the benefit of the procedure, of course, is it's all outlined, right? And you've got a step-by-step process to go through, which can be really helpful to parties. So it's really, I think, going to be based upon a number of factors, one of which might be how big is your department? How often are you seeing these types of cases come up? If it's a very small department, you may not want to go through the process. Doesn't mean you don't have to bargain over it, but you may not have to agree to a procedure, as we're talking about. All right, if Kathy, can you go flip ahead one? As we said, the employee is entitled to the full amount of his or her regular salary or wages. Now, sometimes when you talk to people who are, don't practice in this area or even aren't lawyers, but they know, generally about firefighters and police officers and the benefits that are provided by law, they're still surprised to learn that the benefit, the tax-free aspect of the benefit, is actually in place. So because it is the full salary, and because of interpretations under the workers' comp law and IRS provisions, it is provided tax-free. So it's actually, in some cases, well, in terms of the wages, it's better than actually working, because you don't have any tax withheld from the payment to the employee. Okay, so go ahead, please, Kathy, one more. Recently, we've seen this in other circumstances too, but there's always the question of what is the regular salary or wages, right? Many of us might think, well, I just go to the back of the collective bargaining agreement. I see the salary schedule. I see what a step 4 firefighter makes, and that's what he or she is entitled to. And of course, it's never that simple. So what we're talking about here is what it is we think the firefighter would have received had he or she been working, that are the standard benefits received. So those would be set forth in the contract. And this Borelli case from last year really did evaluate a question of whether these special pay or extra benefits, things like holiday pay or shift differential, night shift differential, were required to be paid as part of a 207 benefit. And again, I think what you need to think about is, what is it that the firefighter or police officer would have received had he or she not been injured? Now, the night shift differential is not an automatic. It's different from the holiday pay, which everybody gets. It would be different from, say, longevity, which everybody gets, or something like a hazardous duty pay, if you've got that in your collective bargaining agreement too. All of those things would be required to be paid, but things that might be more uncertain based upon certain shifts or certain levels of experience that you have to obtain, or certain training, that may not be required to be paid. So it's really, I think, one of the takeaways on this is really need to be really careful about how you phrase the language in your collective bargaining agreement with regard to all of the compensation items, because they may get triggered in the circumstance where you have a 207 application or benefit being provided. So if you are, if you, for example, specifically carve out payment of the holiday pay, let's say you did this and were successful, if you're going to carve out the holiday pay from anyone who's not on active duty, that would create a basis not to have to pay that. But otherwise, it's going to be, something that's tricky to withhold. Allison, did you want to jump in?
Yeah, so one of the things I wanted to point out with this case is it's an A2 case. And for anyone who's in the weeds on 207A, the 2 benefit is the post-separation benefit. So that's where it becomes really critical, and why this case was really focusing on whether an employee had to actually be working in order to receive these benefits. But the case law for 207A and 207C, there's a lot of cases that say we read the statutes together, even though there are differences between them. But big picture items, it's all kind of the same. So this A2 case, even though it relates to those post-separation benefits, it's going to apply because it's the same language when you're talking about A or C. And as Colin indicated on the holiday pay, you want to carve it out. So if you put into your contract that, let's say, you have to work the shift immediately before and after the holiday in order to get the holiday pay, clearly someone who's absent on 207 is not going to be able to meet that standard, and that would be carved out. And then another way to do it is to include a contract provision that says when you're on 207, here are the benefits that you are eligible for, assuming you also, of course, have to meet the statutory minimums. But what else are we going to characterize as a part of that benefit package? And that can also include things about when someone's accruals stop, when they're on 207, and other things of that nature. So it's not just the money items.
Yeah, and I think that's a great point, because if you can get at the contract provision like Allison just mentioned, which is here's the delineated list of the items that are going to be paid on 207, that just clears up a lot of lack of clarity in that area. And I think is a great idea for bargaining, particularly again if you have a lot of the work in this area. So there's, if you could go ahead one slide, the language between, again, the police is the C area, fire is the A area, is similar, but a little bit different. As Allison said, a lot of these statutory differences in language are overlooked by courts, and they kind of conflate the two procedures or the two areas as being treated similarly. But again, we'll cover some of the differences, but again, the idea here is, for example, the statute doesn't require that you provide health insurance to somebody who's on 207. There now, on the other hand, your collective bargaining agreement may provide that all employees are receiving health insurance. So although the statute itself doesn't require it, your collective bargaining agreement procedures, may dictate it. So you've got to look again beyond the statute sometimes. And practically speaking, a lot of this is going to be covered through, if you've got an overlay of the workers' comp process, that's gonna include that as well. I think I cover that in the next slide. If you want to flip that, please. Yeah, so it can include things. So if somebody has a catastrophic, significant injury in the course of in the performance of their duties, not just on the job, in the performance of their duties, it may result not only in a physical injury, but other types of professional services that may be related, such as mental health services. And in my experience, a lot of this is overlaid with your workers' compensation insurance, which will be providing for a lot of the medical care coverage for the injury. So it's not advisable, from my experience, to end any health insurance provisions. The treatment that will be provided will be apportioned appropriately by the provider to either compensation, workers' compensation coverage, or if it's unrelated, through the health insurance procedure. And again, you can't just dispense with that requirement if that's what's required to be provided to employees under your collective bargaining agreement. So the treatment piece, what's important is, just because the employee has returned to work. So let's say, for example, the fire chief or police chief has ordered the employee back to a light duty position. The medical care continues. It doesn't end at that point. Next slide, please. So again, we're really focused on what the regular salary or wages are. So we're going to be trying to ascertain which bucket it goes into. Things like accrual of certain benefits, again, are not statutorily required. But again, as I've seen, many employers have negotiated this benefit to provide for types of accruals. I've mentioned the employer-paid health insurance. That's not a necessary requirement under the law, although a practical requirement in most instances. So I think I've said most of this, but again, really key in trying to make sure that your collective bargaining agreement doesn't expand or isn't interpreted to expand the statutory benefits in a way that would enhance them beyond what they're really required to be. All right, I think we're on to Allison and return to work.
Okay, so one of the biggest issues with employees who are on ARC is getting them back to work. A benefit that Colin mentioned before is the IME. So there is no inherent right in New York State to direct an employee to go to the doctor. It's usually a matter of contract. Sometimes it's tied to sick leave, asking for doctor's notes, etc. Those tend to be bargaining type issues. But when someone is on 207A or C, you, for lack of a better phrase, own them, because you're owning that injury. You conferred those benefits on them. So it's very important during the absence that we just don't let employees sit out there. We're requiring IMEs spaced out at reasonable intervals so that we know what's going on with the injury. We're getting it from an independent doctor as opposed to the employee's own doctor, and they're giving us an opinion about what that employee can and cannot do. That could require include something like corrective surgery. So if there's something that, I don't know, someone breaks their ankle and they need surgery in order to put in some screws and some plates, that would be a corrective surgery that we would want that employee to have, especially if the prognosis is they're going to be completely better and they'll be able to come back to work. When the surgeries are more risky, or whatever medical procedure that's being recommended is a little bit more risky, we can get into a battle with the employee about whether they can actually force someone to go through that process. And that, again, is usually something that's covered by a contractual procedure. So we don't just have the right to say you have to get the surgery. It can become a battle afterwards. If there's a residency requirement, again, this is not a paid vacation. We don't want employees to be off moving to other states. If you have something requiring them to be residents or at least reside in a contiguous area to where you're located, you should be enforcing that. Same thing with stay-at-home restrictions, to the extent when employees not working due to an illness or an injury. If they are supposed to be at home during their work hours, then you should be enforcing that. There's not a pass just because this happens to be an enhanced benefit. When you are looking to schedule the IMEs, because we're talking about injuries, we're talking about disabilities, and these can lead to potential discrimination claims. So your best bet is to be as consistent as you can be, unless there's an objective injury or an illness-based reason for you to be treating someone differently. But when you have multiple employees out at once, maybe there's one that's fallen out of favor, one that's in favor, it doesn't matter. We want to make sure we're sending everybody to the doctor at the same period of time. And if there's not if there's an objective reason for you to distinguish between the frequency or how often you're having them go, then that would be okay. But you need to make sure you're really careful to make sure you can support that objective reason for why there's a difference there. HIPAA releases, those are things, when someone files an application for A or C benefits, I would have them sign that release immediately. Sometimes the lawyers who are representing these employees in hearings will try and make a big stink about the fact that there's not a HIPAA release. To me, it's a distraction from the real issue that's going on at the hearing, but solve that up front. And you can even require that as part of your contract, that it has to be submitted as part of the HIPAA release. These are medical records. Anything that they submit, they're supposed to be kept separate and apart from your regular personnel files, and only certain people should have access to those records, a very limited number. Same rules that we all follow when it comes to sick leave and other type of records that we're maintaining that are medical in nature. In terms of the IME, you can send the employee to an IME to figure out that causal connection when you're trying to make that initial determination, when you're trying to make sure, can they come back to work? Can they come back to work full duty or light duty? I think you get what you ask for. So sometimes you need to direct the doctor, I need these questions answered as part of your report. Otherwise, they could just give you a standard report that doesn't help you. So that could include sending them a job description. If you have a light duty job description, sending them everything that they need in order to answer the specific questions that you have at that time, whether it's the causal connection for initial determination, whether it has something to do with the employee's recovery, or whether they can go on light duty. Because these are expensive and we want to minimize how much back and forth we get with the doctor. Whether you offer light duty that's a managerial prerogative. You don't have to offer it. Once you have offered it, you're kind of stuck with it. The biggest issues that I see with light duty is it's sort of amorphous. It's not defined. So if you don't have a procedure in place that you are following where the light duty positions are available and you know how many of them there are, you know how long they're being offered, and you're having check-ins with the employees medically to see if they're still able to perform those duties, that's a best practice here. If the employee is in the position for too long, you're never going to be able to get them retired, because the retirement system will look at that as their new position. We've now created this position for them, and if they can keep performing those light duty job duties, you will never get rid of them. It's really hard to do that. There are potentially other ways to handle that, but when they're back at work and they're performing light duty, yeah, it's really difficult to get them to actually leave. Once we do tell people they're obligated to go onto a light duty assignment and we're directing them to return back to work, if they refuse to actually return to work, we can technically cut off their payment. Now, there's a caveat there because oftentimes there's a procedure in the contract that lets the employee challenge that decision. And we end up in a battle over, it's usually a battle of the doctors. The employee's doctor says they can't return to light duty and the employer's doctor says they can. Even when the employer wins, I think I've only seen once where an employer actually wants to pursue getting those payments because it's just a period of time that goes from when we start having the battle about having someone go back to light duty and when we actually get a decision. It's not exactly a great comforting position to want to recoup all that money from an employee because it's usually, sometimes it's up to a full year's salary, but statutorily you can. If you decide that you want to enforce this, do it consistently and for every employee that you find is in this position. So when we're talking about the return to light duty and the challenge and the battle of the doctors, we're talking about the medical information. So as long as the employee comes forward and provides information to say, hey, not so fast, your doctor might think that I can do these things, but I really can't. Then we go through a hearing set by contract, most likely, and it's usually in front of a neutral, a hearing officer, an arbitrator that's selected in accordance with whatever that procedure is. And it shouldn't be an antagonistic type hearing, but sometimes it is. But the doctors are being cross-examined, and ultimately you have a hearing officer and arbitrator who's going to make the final decision regarding whether the employee was properly ordered to report back to work on a light duty basis. Another thing that your contract might include is a standard. So was the employer reasonable in making that decision? Was it arbitrary? Was there substantial evidence to support it? Those are all things that come up in the context of bargaining. And if you need assistance with which standard to incorporate, please contact us. It's always best from an employer perspective to make it arbitrary or capricious because that's the lowest level. And that's the one where you're going to have the best chance of prevailing in front of an arbitrator or a hearing officer. So I think, there we go. So now we're moving on to the end when someone is leaving employment or they're retiring, which is going to trigger moving them off of 207.
Thanks, Allison. And just to go back a couple slides, Kathy, I just want to talk with Allison about one other question. So this, or go forward one, please. The due process piece, right? So if you're, I mean, I think we understand if our contract sets forth what the procedure is going to be or who's going to hear it, whether it's a hearing officer or an arbitrator on this light duty question. What would we say if the contract doesn't have that piece? Let's say it has a procedure but doesn't address this piece of it. What do we think, is the standard amount of due process that an employer would want to provide in that circumstance? Do you have any thoughts on that?
I think you at least want to have a meeting with the employee about this. And if they want to bring counsel or a union representative to it, this is not a union issue. It's an individual employee issue, but we oftentimes have employees that use union representatives for these types of meetings. But again, it doesn't hurt to have that meeting. I think you should have that meeting. I think it's part of due process because we're talking about someone's ability to come back to work. And let's say, heaven forbid, we got it wrong, our doctor got it wrong, and we push someone into a position that they're really not ready for. You want to at least hear that person out so you know that the information that you're receiving, that you're basing the decision on is appropriate for that person. So we're looking for, when we're not looking for, nonsense type things where you get a bare bones doctor's note that says so-and-so can't come back to work until X date in full duty capacity. That's not going to, in my opinion, create a genuine medical dispute, but I'm not just going to reject that note out of hand. I'm going to be following up with the employee and say, I need more than just this. Let's figure out what's going on.
Right. Yeah, I completely agree. And some people hear the words due process and they think, oh, wow, I've got to have a full hearing, or I've got to have lawyers there. I've got to have a stenographer. That's not what we're talking about here. I mean, it's basically an opportunity to be heard fully and completely. And you want to, the most critical piece, not only to providing the due process, to be able to prove later on that we did provide that process. So the series of letters, the series of responses, all of that stuff becomes part of the file that we're going to need to defend the determination should it come later on in Article 78 or a grievance process.
And I think here too, because it's light duty, we're not taking away the benefits. They could be on 207 in a light duty capacity, that's where it's not quite the same due process as when I'm deciding to put someone off or on of 207.
Great, thanks. Okay, yeah, so when we're talking about, right, again, so we have to keep providing disability benefits under 207 A or C until the person gets better and returns to work, or the disability ends, the person voluntarily retires, which I've never seen happen, or the person is granted a disability retirement. And the statutory provisions have a number of options for people to proceed under, whether they're a police officer or a firefighter. So once a police officer, is granted a disability retirement under one of these three provisions, performance of duty, accidental, or ordinary, then the obligation for the municipality to continue the payment of salary ends at that point. Ordinary is really the easiest one to achieve. It's for generally off-duty injuries if they're significant. But I would say this as a precursor to all of this discussion about disability retirement is, this is a long process. It is not something, except in the most, clear-cut circumstances, which, are thankfully not as rare, or are pretty rare. The most of the cases can take years to get through this process with multiple denials early on from the system. So it's not a process that you want to kind of let somebody stay on the 207 benefit if you really think they're never going to return to duty. We want to get that process started. Did you want to add something else in on that too?
I would say we also have the power, I think this is another slide, but we have the power to file for retirement on behalf of the employees too. I see a lot of times the employees are holding out for that accidental retirement because it's a better monetary benefit. But in my experience, and we're not part of this, it's all through the comptroller's office, but it's getting harder and harder to meet whatever standard they decide meets that accidental to get that 3/4 benefit.
Right. So take the initiative, get that process started. You have the right to do it. Don't wait for the employee to file for the benefits. This is the next slide, as we just discussed. Can you advance it once? So the disability retirement application can be filed by the employer. Certainly, you want to make sure that the employee is on notice and that any such disability retirement is going to terminate the 207C salary. Again, all of this is about providing sufficient notice and be able to defend the case, later on. If we have an employee who's filed on his or her own, certainly appropriate to get whatever copies, ask for them as part of your managerial right to ask for copies of the application so that you have started a file on your own. Again, employee may choose to select the most preferential retirement benefit, but that doesn't mean you, the employer, are precluded from filing your own under a lower standard. So as this point makes, the employee may be seeking the most, the accidental benefit because it provides the greatest benefits, but we may just submit an application on our own for the performance of duty application as well.
Just add here too that because we're shifting the monetary responsibility for the benefits from the employer to the retirement system, there's not a lot of incentive to make that shift. And one of the things that I have seen come up is there's this obscure provision that talks about the employee has to notify the retirement system. I think it's in 90 days that they have an injury, that it exists. And I've seen the retirement system bounce disability retirement applications because they didn't give that notification that the injury, no matter how far back it goes. So I've seen more and more the unions are looking to put something in their procedures to make sure that employees, because from our perspective, that's the employee's responsibility. It doesn't run to the employer, and we don't want to take on that responsibility on their behalf. But the union will want something in that procedure to make sure the employee is aware. So whether that's a form, whether when we grant an application for 207, we then have to send them that form. But those are the types of things that I'm seeing now go into negotiated procedures.
Right. And the problem becomes if we, if the employee doesn't get approved, the police officer doesn't get approved for that retirement benefit, right? We're obviously still stuck with the payments. So
Right.
the extent we can facilitate the process, the better. Next slide. So firefighters is a little bit different, right? So we're going to continue, and we have to continue the firefighter salary even after a disability retirement is awarded. Of course, there's going to be an offset, so you reduce whatever you're required to be paid to pay by whatever it is the pension level is for that disability retirement provision. So it's only when the firefighter reaches mandatory retirement age, which is going to be determined based on the time that he or she entered the plan or the program, that we would our obligation to provide any salary benefit is going to end. So the next slide, we obviously have, we do not, we can't say you don't get the negotiated increases or decreases as your collective bargaining procedures go on for a number of years, and some of these people can be on the benefit for a number of years. You will, you are going to have to pay any benefit or any salary increase that's negotiated. And that can include, as this case set forth in the city of Newburgh, even in the circumstance where there's a salary decrease. So that can also kick in the unlikely scenario that you've negotiated a salary decrease. That also may apply. Next slide. Now, this is kind of a significant development, I think, because what I hear sometimes from departments is this idea that we've got somebody on the 207C or A benefit who is keeping a position occupied that they could otherwise fill, and the county or the town or village, et cetera, is not inclined to create a new position until that person is holding based on a 207 benefit has been made vacant. So we can, in connection with these cases, I think set forth pretty good precedent to move someone who is receiving 207C benefits off your employment and move forward with termination. Of course, there's still the Civil Service Law Section 71 process, which can be followed as well, where they have up to 1 year to be out in connection with a workers' comp or on duty injury or illness. But in these cases, the departments in the town of Southold pursued disciplinary charges in connection with Civil Service Law Section 75 and town law, I think it's 155, to remove the officers because they did not come to work. It was essentially a form of incompetence. Those terminations were upheld. And just to be clear, this doesn't change anything with respect to the obligations under 207, but it may have some benefit in terms of creating leverage in the relationship with the employee or the union, as well as I said, if you're in a place where you need to open up a spot, that is something that you can pursue as well. Now, these cases also are under, I think, more reasonable due process standards than if you have a collective bargaining agreement with a just cause provision for separation. Might be a little bit more difficult to succeed in that area, but it's certainly something you want to know about, that you have this arrow in your quiver if you need to think about moving forward with termination. These recent cases from last year, I think, set forth a pretty good standard for us. Now, it doesn't, there are downsides, I think, to terminating an employee at this stage as well. I mean, when we've terminated the employee, obviously we have no opportunity to return the employee to light duty, to hold certain other orders over the employee. We can still order and require a IME to determine whether or not the person is still disabled within the meaning of the law. But we do lose some power over the employee in that circumstance. So it's kind of, I think, a case-by-case scenario where you need to examine what's the best option in this situation. It's not we're always going to terminate after a certain number of days, et cetera.
Both of these cases were appealed to the Court of Appeals, and the court declined to take the appeal. So these cases are final.
Great, good point. All right, so let's talk a little bit more with collective bargaining with Allison.
Collective bargaining. So in New York, we have a strong sweeping public policy in presumption of collective bargaining. So unless there's some clear intent to take something away from the bargaining table, it's going to be an issue at the bargaining table. And there's a lot of case law on which different aspects of statutes manifest that legislative intent and which ones don't. And 207A and C are two of them. So one of the reasons why some employers don't end up with a procedure, as Colin talked about the pros and cons of that before, is because they're negotiating and they've never been able to reach a deal. And I've had employers take the position that if we don't have a procedure and a way to get employees off of 207, we're just not going to put them on it. And they've been successful with having that as part of their own practice. A lot of those will eventually end up with procedures. But if we go to the next slide, if you do get a demand to bargain over procedure, it is mandatorily negotiable. However, there are little bits and pieces of that procedure that you may or may not have to actually come to an agreement on. One of those that we've talked about a lot today is the employer has the right to make that initial determination as to who is eligible to go on and get those benefits and who is not. Once you make that determination, the process to challenge it and everything that flows from there becomes something that you have to talk about. If we want to assign someone to light duty, we're not going to get into a battle of whether that's the right decision unless we get into a battle over whether that was the correct decision and whether someone should actually go and be put on light duty. But we don't have to talk to the employee first before we make that decision. We get to make it unilaterally. Same thing about deciding whether we want to tell someone they need to go get treatment or a surgery or something of that nature in order to help them get back to work. Confidential medical records, we need to make sure the employees sign off on those so that we have access to them. One of the things that I think is something to look for in the procedures, and as Colin mentioned before, sometimes you end up with de novo review to preserve that employer right of making the initial determination. You want to make sure your procedure, when you get into an appeal, especially if there's a denial, sometimes we have an employee who appeal that decision. We want to make sure that anything that goes in front of whoever is hearing that appeal is limited to the information that was put in front of the decision maker. So if the chief got X number of medical records, that is what goes to that hearing officer or arbitrator to decide whether that decision was the right one, which whatever standard you're using in your procedure. But sometimes we have where we bring those initial set of documents to the hearing officer, but then we open up the floodgates where anything else can become something that goes in front of the hearing officer, and then it becomes a de novo review. So just make sure your procedures are written carefully so that it's just those documents, because if we're challenging the initial determination, we should only be looking at what was in front of that person. So I think that kind of goes into a little bit of the best practices. So again, you did initial determination. So I like to give employers some flexibility here on the initial determination and not tie their hands there. I think there's something on the next slide about this too, but to set a deadline about when the decision has to be made that ties it to when the application was filed, it never works. We all know that it can be difficult to get documents from doctors' offices. They want certain records and releases so that they're going to be okay to release those documents to someone, and it can take a while to get them. So I like to tie the deadline to something that is, when we have the records that we need in order to make the determination. But be careful about when you make that initial determination and make sure, one, it was an injury that happened in the performance of duties and there is that causal connection. So once you make it, that injury is going to include that 207 designation, not only for that particular injury, but down the road, if the employee ever gets hurt again or exacerbates the injury doing something else, you again have to establish that there's an independent basis to put them back on 207, but it all kind of relates back to that initial injury. So it's harder to distinguish why the initial one is going to be covered and why the exacerbation is not. And sometimes you have procedures where we fight about whether the exacerbation is covered as well. Make sure you get the HIPAA releases early on. So we talked about getting that right when you get the application, that's part of it has to be put in as part of that initial application. Make sure you're being even-handed and objective in terms of when employees are going for IMEs, so we don't get stuck in a discrimination claim on top of having to deal with 207 issues. And make sure if someone's ready to go and you think they are permanently incapacitated and they're not able to work anymore, get them off your payroll, so to speak. It's not necessarily going to cut them off of 207, but it'll at least free up a spot for you to hire someone and maybe cut down on your overtime costs to fill that spot with someone who's able to work full duty. And then I think our last set, I'll let Colin jump in here too. So co-hosts, so something that could be a non-mandatory subject of bargaining becomes mandatory once it goes into your contract. So if you listen to us tell you all these things that are non-mandatory, but they've already been put into your 207 procedures, they're mandatory for you. So beware of that when you're constructing something or you want to start modifying to make sure that we preserve as much as possible the non-mandatory nature of a particular topic.
And one thing I just jump in on that, Allison.
Yeah, go ahead.
Yeah, just in terms of a strategy for collective bargaining, I think it's really important when you're doing a 207 analysis, you're going through the proposals, is to make very clear to the union at the outset, we're not negotiating over this. We don't have to. And, so you set forth at the beginning, these are the items that we'll talk about with respect to 207, but we're taking the position that it's non-mandatory. We don't have to talk about it. Set that forth at the outset.
Agreed. And then I think we already talked about making sure that the timelines are going to work for us and that you have sufficient amount of time, especially when you're making that initial determination. And also just think about all the things that are going to be included as part of the 207 benefits. And do you want to make sure you have that list in the contract? There's caps on how much you can give. So are we prorating vacation time to carve out time that the employee is on 207? Are we cutting off certain, let's say we want to give night differential for a short while and then we cut it off so we don't have to have that fight down the road. Those are things that you can put into your contract and make sure that there's a limit on it as well. I think that brings us to the end, but you have something else, Colin?
Yeah, just one other best practice that I've seen in my experience would be, get set up ahead of time your relationship with either a group of IME professionals or like a clearinghouse that can help find the right IME. That can be, not only is it expensive, but it's also very time consuming. So if you're starting and let's say you have a lot of these or, a few every year, you want to be able to say, this is the group that we're going to be calling upon to evaluate this. Now, each case might be different because it's a mental health case or it's a brain case or it's a cervical case, a spine case. But at least if you have that relationship set up ahead of time, it makes the process of getting the IME scheduled, getting the records to the IME doctor ahead of time, it makes it a lot smoother than trying to start from scratch each time.
I agree with that. I think sometimes you will need that expert. So you're not going to send someone who has an issue with their foot to someone who specializes in mental health. Make sure you're sending them to the right people. But I agree, having those contacts available and at your fingertips ahead of time is helpful.
It's like we might have one question here.
I think someone's looking for the slides. So we'll let Kathy, if she has that information.
Yep, we'll have the slides up on the website by tomorrow.
All right, we're at 1 o'clock, so I think we've used up our full allotment of time. Thank you, everyone, for attending. Here's our contact information. So if there are any follow-up questions, please don't hesitate to email us and ask away.
Thank you.